Jeff Lewis. I saw him, yeah. Mm-hmm. Jeff, just sit anywhere on that back table right there for the moment. And is Senator Kennedy out there? He's not. Okay. He told me that he may be coming later, and what the chair is going to do is call Jeff Lewis. That microphone that you are in front of is number, what's the number right in front of you on the desk there? 11. Jeff, why don't you do this? I know that you were here and you testified on Chairman Estration's bill. Why don't you just give us a very brief review? And if the members have any questions regarding the bill that they've already voted on unanimously, we'll certainly let them be asked. But go ahead and give us a very brief overview.
Thank you, Chairman Fleming. And first, let me apologize for my attire. I was at the office today informal when I got notice that this hearing was going to take place. I didn't have time to put on a coat and tie. I certainly would have. You have accurately summarized the problem here with this decision that came down from the Georgia Court of Appeals on Halloween Day of last year, in fact. And that was to say that this statute of repose, which applies to construction deficiencies, should also be interpreted to cut off any contractual warranty on any building, any improvement to realty in the state of Georgia after 8 years. So this is a subversion of our strong public policy in favor of freedom of contract. In fact, our Supreme Court has said freedom of contract is both the bedrock and the pinnacle of Georgia public policy, and that it is sacrosanct. So the point of the clarification would be to let the world know that freedom of contract is still sacrosanct in the state of Georgia, and this statute of repose, which cuts off claims at 8 years, does not apply to contract claims. Okay. Happy to answer any questions anyone might have.
Well, I thought the duty that lied nearest to us today was to go ahead and and deal with this since it is such an important issue, and hopefully the Senate will move our bill too, and one of the ones will pass. But let's get this one into rules. Chairman Estration, do you want to add anything to that? What's your mic number there?
Number 12.
Yeah.
Thank you, Mr. Chairman. The bill passed unanimously in the Georgia House as well, 165 to nothing. I just want to confirm what you asked earlier. The bill that's before us here is the exact same bill that was passed in HB 968 was the number.
Right.
And fully support what Mr. Lewis has said. Also, we'll just note, members heard of this before, but Clark Howard advocated the General Assembly take action on this matter in the next legislative session, which is what we're doing here. Thank you.
And Chairman Estration, should we pass this bill out of rules, and for any reason if it were to come to the floor, my assumption would be you would handle it just like you did the House bill?
Yes, sir.
Okay, absolutely. Any questions from any members of the committee for our second look at this same issue? Anybody on Zoom? Okay. If not, is there a motion regarding Senate? Well, let's see, we don't have anybody signed up but just Lewis. So any Any motion regarding Senate Bill 451?
Motion do pass.
Do pass by Chairman Administration, second by Chairman Silcox. Any discussion? Any discussion? Hearing none, all those in favor indicate by saying aye.
Aye.
Any opposed, same sign. We will also now, I will turn on the microphone for our members joining us by Zoom. And I will ask you the same question. All those joining us by Zoom who want to vote yes, please indicate by saying aye.
Aye.
Any opposed, same sign. The bill passes on the rules. Despite your presentation, Mr. Lewis, here today, we're happy to help with this issue. Next time I want you in a tux, all right? Yeah, to make up for it, okay? Yeah, and consult with Chairman Administration about that. Yeah, he's well versed in those areas. So, all right, good enough. Thank you so much. Appreciate you being here today. Okay, Senator Stone, will you come up to the center? No, right here in front of me, please, if you don't mind. And if you want, Senator, do you want to ask Adam to come in with you? Adam Cleveland? Okay. All right. Senator Adam, have a seat right there is fine. Our senator and Adam, our speaker, has told us if you're addressing the mic and doing a lot of talking, you are welcome to take your mask off. And so, Senator, you're welcome to do that if you'd like. Senator, we appreciate you being here with us today on Senate Bill 443. As I understand it, this passed easily through your chamber. And as I also understand it, we dealt in a significant way with the issue of garnishments in this legislature 4 or so years ago. Been a while now. And as we do quite often when we deal with a major rewrite, we come back and look at it for a couple of years and figure out the areas that we should have tweaked different left instead of right. And now you've got the tweak it bill for the garnishment, that rewrite that we did, if you allow me to summarize it that way, and you can correct me if I'm wrong. So okay. And you've also, as I always like to have a smart lawyer with me, an expert in the area, you've brought Adam Cleveland, who's helped us before. Yeah. Don't leave home without him. There you go. And I apologize. And your microphone should be on now, Chairman Stone. So why don't you go ahead and we'd be happy to have you today and tell us what you'd like to about the bill.
High points. Several years ago, 2015, federal courts struck down Georgia's garnishment statute. This stopped garnishments all across Georgia and created much disruption. Chairman Willard, your predecessor, and I came together and worked on a bill that we called garnishment reform. It addressed the issues that were dealt with in the federal case and set out to modernize and improve the garnishment process for all participants. That's the plaintiff, the garnishee, and the defendant. As it is with most areas of practice, once the legislature has weighed in and made changes, we hear back from the practicing attorneys about, what do we mean here, and here's something else that can be done to improve efficiency. So we came back 2 years ago with another bill which made some revisions. This year, in the same spirit, we're continuing the process of trying to improve our garnishment process. And I'll hit on a few high points. The substantive changes, that, so to speak. One is that we noted that garnishments tend to cause people to run to a bankruptcy lawyer. And one of the reasons for that is the percentage is more than most people can stand, 25% of disposable income. And quite often the parties would like to lower it, but the process was cumbersome to come up with a lower amount of deduction. This addresses that and simplifies and creates a form for reducing the deduction when the parties want to do that. Along the same vein, we noticed that federally guaranteed student loans have a cap, a deduction cap of 15%. That's lower than our standard 25%. This bill makes that cap applicable to all student loans, whether or not they're federally guaranteed. One thing in the area of continuing garnishments, there's a 6-month limitation on how long a garnishment can run. And that necessitates repetitive filing, opening up new cases every time, much workload for all involved, and adds to the cost. And the costs that are initially paid by the plaintiff are added to the garnishment or judgment. And so by extending the 6-month max to a 36-month max, we are reducing cost for all the parties and reducing workload for our clerks. We've tried to make it easier for unsophisticated garnishees, the people who, the employer who gets hit with a garnishment and he's a mom and pop operation. So we made it easier. They can file paper answers. They don't have to make any effort to determine validity of the judgment. We've also reduced protections for plaintiffs who file wrongful garnishments. The law had put them on the same par as garnishees. Now, garnishee essentially is a third party to the original dispute. And we want to deduct the money and send it to court and all that. But we differentiated the plaintiffs where they may file frivolous garnishments. Now with that, I want to ask Adam Cleveland, who is a recognized expert. He's been involved with all the efforts of drafting over the last 5 years to add to what I've said, because there are some other tweaks, and answer questions.
Mr. Cleveland, what is your microphone number in front of you there? On that should be a piece of paper there with
Mike 4.
Mike 4. Mr. Cleveland, you've been with us before. You were here 4 or so years ago when we had the major rewrite. You were very helpful and we appreciated your expertise. Please go ahead and reintroduce yourself to the members of the committee who may not have been here then, and we'd love to hear from you.
Sure. Thank y'all for having me. I'm Adam Cleveland. I am a sole practitioner who represents largely financial institutions, but also retail businesses and individuals, particularly focusing on garnishments. So obtaining judgments, but also collecting the balances that are owed through garnishment practice. In that capacity, I serve both as plaintiff's counsel in garnishment, but also as garnishee's counsel in responding to garnishments. Every so often as a defendant's counsel in trying to object to a wrongful or inaccurate garnishment. I've been in the dubious good fortune of being in this position for our creditors, kind of attorneys in Georgia for the last several years. And so here we are back to try to make sure that the the garnishment law that we have got to this point is functioning in a more efficient way, and that some of the things that are still being applied differently across various courts in the state are being become applied in the same way. We had the intention with the rewrite to make a truly uniform practice of garnishment in Georgia, and even the 2018 very small bill that made some tweaks to some of the unfortunate discoveries we had after the rewrite process was intended to make sure that the judges and garnishees across the state had the same guidance and applied it in the same way. And unfortunately, we're finding particularly that a number of judges in various counties and courts have got differing estimations of what the statute says. And so this, in a large way, was intended to help make sure that everyone who utilizes the process of garnishment or is responding to that process of garnishment has the same metrics to gauge their responses on. If you want detail on any particular element, we can. I thought Chairman Stone summarized it very well. The idea was that we didn't do anything in here. For instance, one thing that's been a staple of the garnishment law for ages is a 3-day window of notice to be given to the defendants, which basically everyone who's ever done a garnishment will tell you is very difficult to do when the notice is triggered on sheriff's service to the garnishee, which the party who files the garnishment often doesn't
Adam,
have.
if you would please allow me to apologize to interrupt you just 1 second,
Yes.
because I want to, as I speak through this mic, I'm speaking with our media services folks who are helping the people sign in from Zoom. Some of our members are. And Roger Bruce, Representative Bruce, has just texted me that he had a little trouble initially, but he is now successfully signed in, is waiting to be let into the meeting. And there he is. Okay. So Representative Bruce, you should be coming in with us here now. All right. Mr. Cleveland, I apologize.
No, it's no problem at all.
Interrupt
Thanks.
you. This new world we're living in has the meetings running a tad differently. So please continue.
Just fine. So we tried to focus, and I drafted this with Scott Bass, who's here today, who is a representative of a number of very large employer garnishees and creditor corporations in Georgia. But we looked for input from all sources, from the clerks of the courts, particularly of Gwinnett County, where they process the most garnishments of all the courts in Georgia, the judges of that court as well. We also talked to employers and also payroll companies who answer on behalf of employers, which cover some of our largest Georgia businesses. And then, of course, on behalf of some of smaller garnishment clients, defendants, and garnishees, to make sure that we didn't do anything in here that hopefully affected negatively anyone's substantive rights in garnishment, but did make it more uniform in its application and more efficient, less detrimental to all those who had to be in the process. If you want more detail, I'm happy to give it. There's a synopsis we've got. Hopefully some people have had a chance to see that, but that's the gist of it, is that we try to stick with, correcting technical questions.
This is one of those exciting issues, which I can tell several of the members are riveted. They particularly the ones who sat through it 4 years ago for hours after hours after hours, but nonetheless a very important area of the law. But when we have people who know what they're doing, we appreciate you. All right. Any questions from members of the committee for either Chairman Stone or Mr. Cleveland regarding the bill that you have in front of you? I don't see any in the room. And how about on Zoom, Mr. Myers? No? Okay. All righty then. I don't think we have anybody else signed up. So y'all can sit tight for a second. But is there a motion regarding Senate Bill 443? Ms. Chairman Silcox, motion to pass. Is there a second? Second by Representative Jones. Any discussion? Hearing none, all those in the room with me here who intend to vote yes, please indicate by saying aye. Aye. Any opposed? Same sign. Now I will turn on the microphones for our members joining us by Zoom. All those in favor, please indicate by saying aye.
Aye.
Any opposed? Okay. Representative Bruce, I'm told you hadn't unmuted yourself. Your thumbs up. He's giving us thumbs up. My Zoom members here give me, they use fingers sometimes to communicate with me during this process. And so far it's all been thumbs up or thumbs down. So we'll hope that continues in that process. All right. So the bill passes unanimously by my count. I believe Chairman Welch is going to be carrying this bill for you on the floor, Chairman Stone. Okay. We appreciate y'all being here today. Thank you so much.
Thank y'all too.
All right. Okay. Well, okay. All right. Thank you, buddy. Bailiff Silcox, would you see if Senator Stone is? I'm sorry, Senator Kennedy has had a chance to arrive yet? Senator Kennedy, we appreciate you being here today.
Thank you, Mr. Chairman. I appreciate
Thank you very much. I knew that you were going to be running a little late, and we passed one of your most controversial bills earlier before you got here. Do you want me to tell you what it was?
Yes, sir. What was that?
It was actually Senate Bill 451, the same identical bill that Chairman Estration passed through the House dealing with the warranties issue and construction
Yes.
projects.
Correct.
Jeff Lewis came down. We chastised him for, we called him out of the office at the last minute, didn't know he's coming. So he had on a look like a Hawaiian shirt or something.
Did it?
And we told him that he was not properly attired, and we expected next time he need to wear tux to make up for his slight. So
Good.
and,
I think that's proper and fitting.
yeah, I believe it would. I
Yeah.
believe it would. He was, yeah. Okay. Wow.
And that
Wow.
it's been downhill ever since, my understanding. And apparently
I've-
today's appearance proves that, Mr. Chairman.
I've told him quite often he dresses like a dandy. So, all right.
Oh, thank you for that. And maybe I should take a hint from that. Maybe I should just my
Leave and maybe your bill will
my
pass.
bills
Yeah.
may have a better
Yeah.
chance if I don't. if I'm not here.
Absolutely. But we do appreciate you coming, Senator, and you have Senate Bill 464. I think that you have brought counsel with you that has been working on this, and we always allow people to be represented. We appreciate that. And I had only person I had signed up was one other person, except maybe Shelby. That's Shelby. Okay, absolutely.
Shelby Gilbert.
All right.
Yes, sir.
You have a mask on. Yeah, it took me a second. I'm sorry. All right. So Senate Bill 464. Senator Kennedy, good to have you today. Please tell us about Senate Bill 464.
Thank you, Mr. Chairman. And I'll be, with your permission, I'll be rather brief and let Mr. Gilbert go into the details because the concept of this is really pretty simple and straightforward. What this bill proposes is for us to have rules for mediation as we certainly as practitioners know and understand. For court-ordered mediation, there are guidelines that we have and there are rules, but for non-court ordered or for mediation that is not the product of or pursuant to a court order, there really aren't. And so what this bill proposes is to give us a model, to give us a framework for having mediations. It is my understanding, and I'm given to learn that because of the lack of the structure here in Georgia, that we're missing out on opportunities to have mediations that could be international mediations that could be coming to Georgia, but our state is skipped over. So that's really what the bill does. That's the policy driver behind it. That's the reason that I would submit we ought to look at it. And for the details, with your permission, Mr. Chairman, if I could ask Mr. Gilbert to give the highlights of those. And then
Absolutely,
either one
Mr.
of us can
Gilbert. Do you
answer
want to
questions.
come up here maybe to the microphone closest to Senator Kennedy? It's good to have you back. And our speaker has told us that if you are addressing the mic, you're welcome to take your mask off, but that's up to you. So what we'll do is ask you to please introduce yourself to us, tell us what your practice is and so forth, and your how you're involved in this bill, and we'd be happy to hear from you.
Sure. Well, thank you, Mr. Chairman, for the opportunity today, and thank you, Senator Kennedy. Happy to talk a little bit about this act that we're proposing. I'm a partner at King and Spalding in our trial and global disputes group there, and most of our clients are large
Small
business-
firm?
It's
Yeah.
yeah, you've seen the name now on the building. We've gone a little overboard, and now we're all working at home. But I think we're all going to be back one day, and we handle really large business disputes. And this bill really is an outgrowth of an initiative that started about 10 years ago, where we and lots of our colleagues at other firms in Atlanta and also in-house counsel at other businesses in the state started thinking, well, we're getting on airplanes to go resolve our disputes outside the court process in other states or sometimes in other countries, when we could be doing that in Georgia and bringing that business and having people actually fly into the state. And we just started asking ourselves, well, why is that? We've got the best airport in the world. We've got a great business friendly environment. Why are we doing that? And the first thing we did, and this committee helped us with about back in 2012, 2013, was help us pass a new code for international commercial arbitrations. And we worked on that with the Atlanta International Arbitration Society and a lot of other firms and professors in the state of Georgia. And we passed an international arbitration code that we've started to see the benefits from over the last few years in terms of more folks coming to Georgia to resolve their business disputes in Georgia, which means not only the fact that you got more lawyers running around and you got people going to restaurants, flying in, staying in hotels that wouldn't have otherwise come here because they would have gone to New York or to Miami or to some other location to resolve that dispute. And we've got a great code in place, starting to see some results there. And that's what this act would also do. And that was our initial thought process was, why are we getting on planes and resolving mediations elsewhere? And there are a couple of reasons for that we identified initially with our committee that we formed at the Arbitration Society. And one of those is, as Senator Kennedy just mentioned, we've got a great set of rules in the state of Georgia for court-connected mediations. But most of the big business disputes where you have people flying around and coming in to resolve disputes from other states, those are resolved in voluntary mediations. So those mediations are not governed by the Georgia Supreme Court rules that are promulgated by the Georgia Dispute Resolution Commission. So that's one problem that we currently have in Georgia that this bill would resolve. And as we got
Mr.
into
Gilbert,
this,
let me interrupt you and ask you to pause just 1 second. As a minute ago, I was referencing, because we have people joining us by Zoom now, occasionally there are audio issues and whatnot. And I'm told our legislative counsel, Mr. Talbert, was unable to, he lost his audio. Mr. Talbert, do you still have no sound? You can give me a thumbs up if you have, a thumbs down if you have no sound. He wouldn't be able to hear me, would he? What am I thinking about? Let me see. Representative Bruce, can you hear us? Give me a thumbs up. We got Holcomb can hear us. So it seems to be working for some people, but not all people. Mr. Talbot, you're not muted on your end by any chance. Well, once again, he can't hear me. I'm sorry. Can you, you're texting with him. So I don't know if he needs to try to sign back in. But you can let him know that other people are able to hear from the Zoom audio, and that it may be something more on his end than with the system. So what we'll do is we'll work on that, Mr. Gilbert, and we'll let you go ahead and continue. And I apologize for stopping you there midstream. You were doing too well. We had to call a timeout. So go ahead and finish,
Okay.
please.
Well, with that background, we thought we identified an issue that there are all these voluntary mediations, and that's the type of mediation that I'm concerned with and the business community is concerned with, because those are mediations, not where a court tells you got to mediate, but that's because the businesses decide, well, the courts are clogged. We want to mediate because we think that may be a more efficient way to resolve our dispute. And we were getting on planes and going elsewhere. And one of the reasons that we identified for that is that the Georgia Supreme Court rules just did not apply to what we were doing. There was no code, no set of rules that you could look to that would say that mediation, for example, is confidential, and that what you say in the mediation would not be used against you subsequently 3 years down the line in some other lawsuit that has nothing to do with your first dispute, but you said it in the mediation. Some lawyer knows about it, and then that might be discoverable later on down in the process. And that was a real issue for people that I've talked to personally about, let's resolve the dispute in Georgia. International business thinking about resolving that dispute in Georgia tells me, well, point me to the code that shows that the mediation is going to be confidential and the courts in Georgia will enforce that. And we don't have that. Now, what do parties do in the absence of that? I'm sure lots of lawyers can draft up a mediation confidentiality agreement and say that everything said in the mediation is privileged. But when you're talking about mediations that go across international boundaries, there are real questions about whether those types of agreements are enforceable. And if you got a statute, that just makes the process much more seamless and easier for everybody concerned. So people get comfortable with coming here instead of going to New York, going to Miami, or going to London. And I think that we're missing out on some opportunities there. Now, we started looking at this just from an international business perspective, our committee, and we realized that we were needed to bring in some other stakeholders into this before we came to the legislature. So we've really put a lot of thought and study into this over about a 3-year time period. So this was initially, as I mentioned, an outgrowth of several large law firms and the Atlanta International Arbitration Society's legislative committee. But we formed a working group with the Georgia Dispute Resolution Commission and went to Judge Oslander, who was the former chair of the commission, and just wanted to see what his thoughts were. And his first reaction was, well, this is great, because this makes it easier and makes my job easier, because I can point folks not only to the Georgia Supreme Court rules, but to this easy to read statute, which would not supersede the rules, but is a little bit easier for parties to understand. And he thought it was a great idea, but he said, I want you to remember the rule, don't do any harm here to what we've already got. I want you to study this, form a committee, and make sure that there's nothing here that you're proposing that would conflict with the good rules that we've already got in Georgia. So that's what we did. And we formed a group of a number of task members representing different stakeholders in the state of Georgia, including the Georgia Dispute Resolution Commission. We brought in non-lawyer mediators, and a lot of mediations occur in this state without the participation of any lawyers. You think of a family or religious dispute. We brought in folks from that community. We brought in folks from different law schools, and we sat down and studied the issue for about a year. And then we went back to the Dispute Resolution Commission, presented our findings, and recommended that we move forward with what is based on the Uniform Mediation Act. And that's largely what is in our bill that's been placed before you. And after we made that recommendation, we took that then to the Georgia Judicial Council, and the Georgia Judicial Council agreed with the proposal. They thought that would be great for the courts and would potentially help unclog some business disputes in the court system. And I think that's going to be even a bigger issue now when courts haven't even been running for the last 3 or 4 months. So that's what we presented to them. They unanimously agreed that it was a great idea. Actually, they've done that twice. This was a proposal that came out of the dispute resolution section of the Georgia Bar, went through the Board of Governors process at the Georgia Bar Association. So this is a bar bill, and it's gone through that whole process. And we think it's a great idea. It solves the problem I mentioned about court-connected mediations. It's a uniform act that's familiar, and this legislation in this form has largely been adopted in 12 other states. It's in the legislatures in 2 other states in the country. And portions of this have been enacted in the legislation of other states where we compete for this type of business, including Florida. So it's familiar in this form to practitioners from other states. And we think that that's also helpful. And it also solves an issue about conflicts of interest. That's something else I've had to deal with when folks are coming in to mediate in Georgia with a Georgia mediator. There's no process now or no requirement that a mediator disclose potential conflicts of interest if you're a voluntary mediation. There is in the court-connected rules, but not in the voluntary mediation process. So this puts everybody on a level playing field, and we think that this is a really good bill. We haven't really seen any opposition. I understand that there may have been email this morning about some concerns about the placement of where this would actually go in the Georgia code. And if, I don't know if the gentleman who raised those is here today, but if there are any issues about the placement in the code, I'm happy to address that. But other than that, we think this is good for business. It's not going to cost the state anything, but it is going to bring economic benefits to the state.
Thank you, Mr. Gilbert. Why don't we do this? Do you have a copy of the bill there?
Yes, sir.
Okay. Why don't you take us through the bill section by section and tell us exactly what the changes are and what it does. And before we start that though, I see Rusty Sewell with the Georgia Bar Association back there, and you did say that this went through the bar's process, Board of Governors vote
Yes, sir.
and whatnot, and also as a uniform act, this is going to be pushed for all states, I
Yes.
assume, to adopt.
Yes, it was originally, most of the language here was drafted by the Uniform Law Commission. I understand Senator Kennedy's had some involvement with that commission in the past and could speak more to their process, but this is an outgrowth of a lot of study that went into this at a national level. And this act has been approved by many bar associations. Is a good model. Now that some states like California, they're not, they'd be the model, but have a completely different system in place. And as a result, you see a lot more litigation. But that's one other thing that this act would do, is it would create a uniform set of rules so judges don't have to guess and make up the rules as they go along.
And so what I'd like to do is we walk through it, if you don't mind. Although we start obviously on page 1, right around line 16 there. If line 16 has a great correlation to line 155 and they work together, you feel free to skip around
Sure.
as you explain stuff to us. But obviously, line 16 appears to be some definitional definitions there. Is that correct?
That's right. So line 16 is where the definitions start, and these definitions are largely the same as the definitions that are in the Uniform Mediation Acts of other states. Should be familiar to practitioners from out of the state of Georgia, which we think is important that you have all these up front to make it clear that this is really the same as what other states are doing. We're not trying to change things up here, and that's
Mr.
critical to
Gilbert,
getting business.
if I may, once again, and what I'm looking for here is exactly what you're doing now, but also I'm always very interested in, okay, here's where we're going to change something of the way we operate currently.
Okay.
And because all of us have been in mediations probably at one time or another, maybe not as high level as some, but I'd like to understand how we're changing Georgia law.
Okay.
As you go through it part by part, if you also focus on that for us.
Okay, well, I don't think that here we're changing Georgia law with these definitions. I
Okay.
think they're largely consistent with what's in the Georgia Supreme Court rules. Just they would apply to voluntary mediations. Now, Section 2 talks about the scope of the mediation and when this would apply and when it would not. And
When you say section 2, what line?
that starts at line 48.
Okay.
And this talks about the types of mediations to which it applies. This again is largely consistent with the Georgia court rules, but it goes beyond that because it says it would also apply to those types of mediations where it's a voluntary mediation, which is currently excluded. Now, it does exclude certain categories of disputes.
Let's stick on that for just one
okay.
moment as you go through this. So currently, obviously there is court-ordered mediation. We're all familiar with that.
Right.
And then there is the mediation, I think you termed it voluntary mediation, where the parties get together beforehand. So what we're going to do is now put rules in place where none existed for those quote unquote voluntary mediations.
Correct.
Okay. And the purpose for that is?
To eliminate confusion in the case law and to make it clear what the rules are and to level the playing field for everybody.
I always like to know, are we the majority rule or are we the minority rule when it comes to the 50 states? I mean, on that issue, do you have any idea where Georgia stands in comparison to our other 49 states?
Well, as I mentioned, there are about 12 states that have adopted largely this bill.
Mhm.
There are about 20 states that have adopted some legislation that addresses some of these issues, but maybe not all of them in the same way. But the trend is going more in the direction of the Uniform Mediation Act right now. There are a lot of other states that just have the court-connected rules. I think that those came out largely with the outgrowth of mediation in the late 1980s, 1990s, and that's around the time they were put into force in Georgia, and that's what some states have.
So, but to the specific issue, and if I'm asking it wrong out of ignorance, which I do quite often here, please feel free to correct me. But I was trying to think about how many states have this distinction of what I will call court-ordered mediation and then voluntary mediation, and do the same rules apply to all? Do you know the?
Yeah, I don't know the exact breakdown,
Sure.
but I think that it's about half the states don't have any statutory rules that
Okay.
would govern it,
And but the trend is going toward it.
the trend is certainly going toward it.
Okay. Yeah. Go ahead. I think you were on line 48 in that area.
Yeah, so you start at line 48, defines where the mediation will apply, then you go to 57, and it says that this will not apply to certain types of mediation. So it would not apply to a collective bargaining dispute. It would not apply to certain disputes conducted under the auspices of a primary or secondary school. There's certain reasons why you wouldn't want something involving minors at an educational institution. You wouldn't want this act to apply to that. Or parties, if they want to, could opt out of this if they follow the procedure set forth in line 69. Now, if you start around line 75, there's a discussion about how a mediation communication under this privilege or under the section would be privileged. And it defines what the privilege would mean. It would mean that a mediation party, if asked to, so a mediation party, somebody participating in the mediation, can refuse to disclose what happened in that mediation, subject to some exceptions that we'll get into in a minute. But we don't have a statute like that in the state of Georgia that addresses this issue. We've got some court-connected rules that get at the confidentiality issue. There is some language in the evidentiary code that talks about how things that you say in a mediation can't be deemed admissible in that proceeding that it's trying to resolve, but it doesn't speak to a privilege that might impact your ability to protect those communications in some other collateral proceeding. And that's what a lot of businesses are concerned about. And that's where I've had the discussion. So this is a little bit different from what we've got in Georgia law, but Florida, for example, has this in their code. They don't have the Uniform Mediation Act, but any Uniform Mediation Act state's going to have this privilege, and we just don't have it. So you talk to practitioners all the time, and they say, well, whatever I say in mediation is privileged, and that's just not the case in Georgia. And we don't have a Georgia Supreme Court decision that says that, and that creates some uncertainty. And that's one of the issues that this bill is intended to address. Now,
But we do have an evidentiary code section, do we not, that touches on this?
well, we have a evidentiary code section, and that's a little bit different. And that's in section 408 of the evidentiary code. And there is some language there that was added when the evidentiary code was updated that says that a mediation communication is not admissible, but it's limited to that particular proceeding. And there are limitations on how you can enforce that particular privilege and shield that communication from being disclosed to others.
Privileged information, and once again, the simplistic question here, privileged information cannot be gotten to by discovery.
That's right.
But just because you can't admit something into court doesn't mean someone can't find out what was said.
Correct.
And is that the?
That's it in a nutshell.
Okay. Go ahead.
So if you look at starting around line 90, so you see line 75 defines what the mediation privilege is. Starting at line 90, talks about how parties, if they want to, can waive the privilege, talks about a process for doing that. You go down to, and currently, again, since we don't have a mediation privilege statutory in Georgia, we don't have the need for that section. You go down to line 103, and then there's some exceptions to that privilege. And again, we don't have this currently in the state of Georgia. There are exceptions to confidentiality in the court-connected rules. And when we studied this, we didn't see anything here that conflicted with the rules or would override this, but it's got a lot of exceptions here so that courts don't have to make these up if a dispute arises. And for example, if there's a threat in the mediation to commit a crime or to inflict bodily injury, that's not going to be protected under this statute. And these have all been well thought out, I believe, by the Uniform Law Commission and studied, and they've worked well in other states that have adopted the statute. There hasn't been a lot of litigation about these, which signals to me that they're working well in other states. Now, you go on to Section 6 of the Uniform Mediation Act and of the bill, which starts at line 140. And there's some discussion about what a mediator can and cannot disclose to a court regarding a mediation. And again, these are consistent with the Georgia court rules, but we don't have this for voluntary mediation. So a mediator can't really disclose to the court exactly what transpired, but the mediator can disclose that a mediation happened. Can also disclose things to public agencies if the mediation revealed something. And if you look at 149 about that would evidence abuse of children. And these are some of the other subsections that we worked on because we wanted to make this interact and work with other parts of the Georgia code to make sure that we weren't overriding other parts of the code. So you'll see some cross references to other parts of the Georgia code here. You look at line 154. This also reinforces the concept that mediation communications are confidential, again, consistent with the Georgia court rules, but this would apply to voluntary mediations. And Section 8 of the code, starting around line 158.
Let me ask you a question.
Sure.
Is relating to open records. So mediation communications are confidential. So that means that if a governmental entity is involved in a mediation trying to settle a dispute, the same confidentiality rules apply to them as any private party. Is that what it basically means?
That's correct.
It's a thought process there that if you didn't allow that, you basically wouldn't be able to effectively settle disputes through mediation.
Correct.
With the governmental entity. Okay. All right. Thank you. Go ahead. I'm sorry.
No problem. So Section 8, starting at line 158, is the part I mentioned earlier about conflicts of interest. So in the court-connected mediations in the state of Georgia, that's something that all mediators have to do. But you don't have to do that in voluntary mediations. And it was funny, we actually took this to a lot of the mediators who aren't court-connected mediators under the Georgia Dispute Commission rules. And we said, well, is this okay with you? We don't want to, by imposing requirements that you keep a conflict list that would deter you from serving as a mediator. And they said, well, despite the added administrative burden, we see the need for something like this. And it makes sense. In the same way, a lawyer is supposed to disclose conflicts of interest to their client. This is what this would do. And it would put the voluntary mediations again on the same playing field as the court-connected mediations. Now, what this would not do that the Georgia court rules does, and this would not override the Georgia court rules, is that the Georgia Dispute Resolution Commission rules require mediators to go through a training process and to be recognized as Georgia court-approved mediators. And this would not override that process for the court-connected mediations. You don't have to do that, of course, for the voluntary mediations. Go down to 1.7.
If I could, on
Okay.
that issue of conflict. So this is once again the mediator. Just like if an attorney can't get into a case where there is a legal conflict for them.
That's right.
Are we talking about legal conflicts, assuming that the mediator is an attorney, or does it go beyond that?
Well, it goes beyond that. It talks about if you've served as a mediator for a client for all of their cases for a period of 30 years and you served as a mediator for 40 times, that might create an appearance of a conflict. If you're thinking of a business from outside the state of Georgia that's mediating in Georgia and they don't know if the particular mediator has got pre-existing relationships with the attorneys or the particular client and thinks, well, maybe I don't want to mediate if I don't really know what those relationships are. This addresses that issue, and the mediator was supposed to disclose those types of relationships in advance of the mediation.
So I'm thinking about what you just said. And in Augusta, I have a retired judge that I have used for several mediations, and many people do. He does a good job. So if he were to mediate for me in the future, if this were to pass, whatever lawyer comes in, he at some point beforehand has to say to them, I have mediated 17 cases for Mr. Fleming in the past and blah, 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 whatever.
Yes, and that's something that many the larger mediation societies like JAMS, I don't know if you've mediated with them, or Henning, they already have rules, and those are considered the best practices for mediators now from an ethical standpoint. But yes, that's what it would require if that mediator's not doing that right now.
How is he going to keep track of how many times he's mediated for me if he's really not sure?
Well, I think that we have to figure that out. Let's see if we've addressed that specifically in the statute. I think the standard here is in line 161, that before accepting the mediation, the individual who's requested to serve shall make an inquiry that's reasonable under the circumstances and to determine whether there are known facts that a reasonable individual would consider likely to affect.
What line are you on now? I'm sorry.
That's down at 161. So what would a reasonable individual consider likely to affect the impartiality of the mediator? Because the mediator, I know the process works because people expect the mediator, unless they don't want them to be impartial. And that would include, do you have a financial or personal interest in the outcome of the mediation? You've got to disclose that. Or do you have an existing or past relationship? Now, does that mean going back in time and creating a list of all 50 times that this judge may have mediated a dispute for you? I don't think that that's what this language requires. It only requires what's reasonable under the circumstances. I'd interpret this to mean that the judge should disclose, well, I've know the chairman and I've mediated a number of his disputes over the last 20 years. And
let me ask this question on that. I'm not going to go on this too much longer because I want to let the whole committee, and I just wanted an overview for us. But the two parties pick the mediator.
That's right.
Why is that burden not on them to ask those questions rather than for the mediator to have to disclose that?
Well, and believe me, the amount of due diligence that we do on behalf of our clients in selecting a mediator at a big law firm, we do that. You think about other types of mediation. So you think about the business that's trying to do business in Georgia for the first time. They may do some due diligence, but may not ask the right people and may not have the right law firm engaged to get those questions answered. That could be an issue, or a perception that they're not getting the right answers because they're not familiar with the court system in Georgia. They're not familiar with the way we do business in the state. The other issue is, remember, there are all of these non-lawyer mediations that occur in the state. So you may have a situation where you got one side's represented by a lawyer. They've done their due diligence. The other side is not. And they just say, okay, well, sure, well, I'll use this individual. I know him from my church. I know him from elsewhere, and may not know all of those other business relationships and not be well equipped to do that type of due diligence.
Okay, good enough. We'll come back to that. I'm sorry, go ahead.
No, go down to.
I'm trying to keep you lost and confused now. I mean, if you keep finding your spot again, I'm not succeeding. So
No, you're doing great. So line 178 just talks about how an attorney or some other individual can go to the mediation, and that just means you can bring somebody with you, and you can be represented, or you can have a personal representative. If you go to line 182, this section talks about international mediations. Now, the Uniform Mediation Act, and this goes to what we were first initially interested in at the Atlanta International Arbitration Society, was how do we promote more international mediations? And the Uniform Mediation Act already incorporates law on how you do that, and has some laws that are familiar to foreign businesses outside the United States. What this does is that the Uniform Mediation Act that was enacted, I think when the Law Commission got together back in the late 90s, early 2000s and studied this, they had the uniform law on international conciliation of disputes. And that's not a term that most people were familiar with. And that international law was updated about 2 years ago. and another convention. So we would incorporate the updated version that I think is best practice. And actually, and with that part of the statute, Georgia would be the first state in the United States to incorporate the updated version of this code. And I think that that would really create some positive buzz for the state. And you think about right now where people haven't been getting on planes for a while to go mediate. I think that's going to come to an end. We're all trying to do it virtually right now. And you miss a lot when you try to mediate a dispute that way. And people are going to start getting on planes, figure out where to go. And if we've got some of the things that are in this statute in the updated version, I think that's going to help put Georgia on the map once this pandemic's over and people are doing things face to face again. Section 11 of the act, starting at 197. This deals
Line what? I'm sorry.
line 197 on
197,
the last page of the bill. This deals with electronic signatures, and it basically says that this is not going to limit the ability to authorize electronic delivery of notices described under this particular federal act here. I think that that's not really the main substance of the act, but that's in all the versions of the Uniform Mediation Act now. I think you look at line 202. This is an important provision and goes back to what I talked about earlier about how this is a uniform act. And this is a signal to the courts in Georgia that if there's a dispute arising under this particular statute and the courts are trying to figure out, well, how do we interpret it, that due consideration should be given to how other states that have a similar statute should have interpreted. Now, I think that in practice, that's what most judges are going to do, but that reinforces the concept of uniformity because, again, we're trying to signal that for particularly interstate commerce disputes that are resolved in that manner, you don't have to guess as to how a court in Georgia is going to interpret this law. I think you look at line 205. This is a severability provision that says if part of the statute is not applicable or invalid as to some person for some reason, the rest of the statute remains in bill. No one expected a global pandemic, and we suggested this go into force, hoping that we could get it through the legislature this year and the governor would sign it this summer. This July 1st, 2020 date may be optimistic, but we hope that this could go into force as soon as possible.
Given the fact that under a normal calendar, the governor would have signed this, and I see that it doesn't have an enactment date, which means it would have gone into effect July the 1st, I believe. Somebody correct me if I'm wrong. That would have given a June and maybe a May, a 2-month leadway into this. If the governor were to call this bill or sign it, and let's say we adjourn before July the 1st and he did sign it, would we want it to go into effect the next day or two, or would we want that 2 months that we initially had into it?
Well,
Mr. Chairman, I cannot immediately think of any reason that we would need the additional time. My instinct is like yours, is little time, but at the moment, I can't think of a reason not to fairly effectively immediately go into effect. But I would, with your permission, ask either one of these gentlemen if they have an opinion.
Mr. Sewell, you want to comment on that? It looks like you.
I will.
Behind your mask, you wanted to speak.
Through the mask?
What number is your microphone? It's on the table in front of you.
Okay.
Yeah, and you can take it off if you want to. You can leave it on. It's up to you.
No, I'll just leave it on if everybody can hear
That's
me.
fine. I hear you.
That's a very good question, and not only for this bill, but for most bills, the governor usually has 40 days to sign them. Is that going
I had to refresh my memory on this too. So actually what our code says is, as y'all all know, we love to ask freshmen this question when they're in the well for their first bill. And tell you there's no enactment date in here. Even if, we pass it, how's it going to become law? Our statute actually, however, provides for 2 dates. If the governor, if we adjourn and he signs it before July the 1st, it goes into effect on July the 1st. If we adjourn after July the 1st, it goes into effect January the 1st.
Okay.
That's what the current statute says on enactment dates. And so in this case, if he signed it in July, you would have the issue of it retroactively applying to someone who had already begun a mediation, I think, but I'm gonna let y'all think about that and then think about how you want to potentially deal with that.
And Mr. Chairman, if I
Yeah,
may, I
Skipper.
hadn't thought about that before today. I think we probably want to build in a little bit of a buffer, because you think about people that have already started planning mediations. So you go back to that conflict of interest provision, for example.
Right.
It'd be hard to apply that retroactively.
So you may want to give that some thought as we, Mr. Sewell, did you have something else?
Yeah, my thought, and I'll reserve to our author too, is that we would probably change it and make it January the 1st, just because of what you're saying there. Because I think,
Well, that
It
would put it
puts-
going into effect. Yeah. The law
January
would go
1,
into effect. So, yeah.
2021,
Mhm.
you know, put it in there. Or if, as you said, the law is, if you take the effective date out, it would be January 1, 2020, because I doubt that he's going to sign anything that quick.
Okay. Y'all can continue to give that some brain power if you want to. The last issue that I wanted to raise, and then we'll obviously open it to the committee members. For lack of better understanding, and you're happy to correct me on this, my sense is that this is pretty helpful with making Georgia and keeping Georgia a place for people to do mediations, particularly with our airport here. You know, we want folks flying in from all around the world to come to Georgia or the United States to do mediations here. That's what we do with our corporate code area. We update it to keep us competitive with other states and hopefully put ourselves at an advantage for our businesses and our citizens and whatnot. And also the bigger the mediation, I'll use that term, you know, I would see where this would play a pretty important role, because the parties would be very sophisticated in what they were doing. I know there are exceptions to this next point I'm about to make, but my little question about this retired Superior Court judge that I use and several people in my area use, I think most of us have done pretty well doing that for a long time. And why do we want to adopt this, which now has potential changes to it? I don't know. And where I'm going with this is an opt-in and an opt-out option. Would we want a possibility for people to have to opt into this or opt out of this? I just throw that out there for you to think about, and you may have some very good reasons why that's not acceptable and it wouldn't work. But it would seem to me that particularly the kind of folks that you may deal with at King and Spalding, if there was an opt-in or opt-out provision, that would be easy for y'all to deal with. Now, you can respond to that if you want to, or you can think about it, but I just throw that out as the last question and possibility.
Well, to your first point, I think you hit the nail on the head, that we are trying to continue advancing the code. And that is, at least from business standpoint, from the Metro Chamber standpoint, they're behind this bill. That's why we want to do this. I was speaking to the South Carolina Bar virtually, not live, but last month. And I told them what we're trying to accomplish in Georgia. And they said, gee, that would be great. We're about 10 years behind you, but maybe we could leapfrog you if you don't get it through this year. And I thought that was an interesting comment.
I live in Augusta. I know what you're talking about.
But I think that it's important that we continue to signal that we're open for business, that we're open for resolving disputes. And by bringing folks into Georgia to resolve these disputes, it's cost neutral to the courts in Georgia. So if anything, you go back to the judges who we've talked to and the Judicial Council, to the dispute resolution commissioners, they think, well, not only that, you're going to bring more of that positive economic activity to Georgia. You're going to help reduce the spend for the court, because you're going to make it easier for us to get mediations done. Even if this doesn't change the court connected rules, they think it makes their job easier. Now, to your point about an opt-out, I believe that there already is an opt-out in part of the statute. It's not asked to the whole part, but I believe it is in, at least as to the privileges. in line 69. There's a possibility of an opt-out, that parties can opt out of those sections of the code.
So if that is offensive to anybody's thought of how the law should be, you're saying that they could indeed opt out?
If the parties agree in advance. and
You'd have
assign
to
a
agree to
rep-
opt out. In other words, not opt in. It's an opt out, not opt
Right,
in.
it's an
Okay.
opt-out.
Okay. Okay. All righty. Okay. Let's do this. I know that you told me earlier, Representative Bruce raised his virtual hand. You good? You good right now? Okay. So let's, the chair will now take questions. I do see Representative Rich has a question.
Thank you. Thank you. It's good to see you again. I do have a question. I'm trying to reconcile a couple of things from what I read in the bill and what you said. On lines 49 through 52, I read that to say that this Mediation Act will apply to mediations where the parties are ordered to mediate by statute or court. But you also later said that these will not override the rules that we already have in place. So if this act does apply to court-ordered mediations, then what do the rules that we have in place apply to?
Well, the rules that we have in place, and this is really critical to the Dispute Resolution Commission in particular, since they promulgated those rules go beyond the statute already. And they do things, like I mentioned earlier, they have qualifications that a mediator for a court connected mediation must have. There are other things that has to do with reporting that they have to do when they report back to the court under those rules. And this statute would not do that. Now, there are a few things in this statute that I think provide some clarity that's not in the statute as to this particularly as to some of the privileges and confidentiality. It tightens some of those things up, makes it easier for Judge Oslander when someone calls him up. It says that he can point them to the code rather than having to dig through the rules and look at a lot of cross references and how those have been changed by different local courts that have gotten into, well, we've got our own internal operating procedures. This simplifies his job. But we studied that very carefully and made sure that at first, the principle of do no harm, we don't think that we're getting rid of anything that's in those rules. We're just making them easier to apply.
And if there were a conflict, this act would control.
This act would control.
Okay.
I have one more question,
Please,
if I
go ahead.
may. I understand a lot of these provisions are really critical to these international mediations, and they may not be as critical to our domestic ones where we may voluntarily agree to mediate and have mediation agreements that address some of these issues. Has it been discussed having this apply only to international mediations as opposed to domestic ones?
Well, that's how we started. And we thought, well, let's just do a narrow statute. And I was talking with Rusty about this a few years ago. And he said, well, there's not a lot of interest sometimes in passing just a narrow piece of legislation that only deals with a narrow set of types of business disputes. And that might be a harder sell. And I didn't defer to Rusty on what you get through the legislature. That's not what I do. But he encouraged me to talk to other people that do mediation in the state. And that's what we did. And that's how we came up with this, because we identified this issue of all of these mediation, I mean, thousands of mediations in the state that have no set of rules that govern them, that occur outside the court connected process. And that was what was important. That was an eye opener for me. Deals with that issue. And then it also deals with mediations. Let's say it's not an international mediation, but it's a mediation between a Georgia business, and this happens all the time, a Georgia business and let's say a business in Chicago, and you're trying to figure out where to mediate. Why do we go to New York all the time? It's a domestic one. And there are reasons. New York's got a well-defined body of law. They haven't enacted the Uniform Mediation Act. It's in the legislature there, which is interesting, but people are just comfortable with New York, and it's New York. But why? And this gives us something to talk about and say, well, you can safely mediate here. You're not going to have problems with the courts if we reach a deal in the mediation.
May I ask one more question? You may have given this to me a long time ago, but do you have a list of the 12 states that have adopted it? And the years that they did adopt it so that we can kind of see the trend and see what states
Sure,
have
I
moved
can
in
get
that
that.
direction?
I think I can get that to you. We've got an executive summary of the statute. Could email that to the committee later today if that would be helpful.
Okay, thank you.
Mr. Sewell?
Can I follow up on Representative
Go ahead.
Rich's
Go ahead.
second question, since as Shelby mentioned my name, while it started as an international thing, then when they went to the Supreme Court Dispute Resolution Commission, and Tracy Johnson's outside, she runs that, and it was kind of felt from the people, once they looked at it, is that the court rules, which basically what we've adopted here is the court rules. Like as the chairman was asking about conflicts, that's in the court rules. If you it's the same setup there. If yours was a court mandated, the judge or whoever you went to has got to explain if he knows any of the parties, just like anybody else. And it was felt that it was better to bring those to everybody, because we have had some cases where, like, the courts, our courts have looked at some of the contracts that were written by good attorneys, I'm sure. Sometimes a non-attorney mediation person doesn't even have a contract, disclosing that, this is privilege or you can't get this information. And some of the courts have said, look, I'm not gonna look at a contract. I'll look at a law, but I'm not gonna look at a contract. And I think that's where the commission looked at it, aside from what, Shelby is looking at for international, and saying, this is something that ought to be, we need in Georgia to set some guidelines so people don't get messed up. And that the court rules have worked very well in the past, and we want to continue those.
Representative Oliver?
I am frequently want to stay with my first principle of do no harm. And I am distracted this morning.
Tap your mic. It's working. We just want to make sure.
I'm frequently want to focus on my general rule is do no harm. And I'm confused and distracted, and I apologize to Mr. Gilbert because he really tried to help me with the history, but I'm confused about the history of when we, as a separate statute, included the non-lawyer mediators and the there was an expansion of mediation for the expansion of the rules, which I think we did previously. There was a creation of some bill historically to assist the International Arbitration and Mediation Group, and I think we funded things at Georgia State Law School. And I have had mixed information as to whether or not any of that ever, was that an effective use of money? Have they used really cases? Who is our real competition? And you're here today to say that Georgia wants to be more competitive, but how have we done in the first 10 years? Mm-hmm. In the area of do no harm, I'm talking about the things I'm distracted about, Mr. Chairman.
You can let him answer that if you want to come back, or if you want to continue,
I could
that's fine
just
too.
say one more thing.
Sure.
The real world of mediation is people without lawyers in tens of thousands of domestic and family disputes. It's not international lawyers. It's not international mediations where King and Spalding's at the table. Mm-hmm. Line 178 to 181 refers to something that's a common problem in the real world of mediations in family law disputes. And I can't figure out what this rule says, and I'm just using it as an example. Does the second wife, the former husband, the current boyfriend, the family extension of tension come into the mediation? This rule seems to imply that it's up to the party, but I don't understand what may means. I'm just using this as an example.
Do you follow her question there?
And where I'm going is, this is a very involved discussion. Do we want to have that today, or do we want to perhaps put this bill on the table so that we can kind of bring together what this history is and what we're trying to accomplish, for what purpose, other than to assist the international crowd who has a viable business interest I just need to know more about all of this.
That's a fair question, but I would remind you that it went through the bar process. So
I'm on the
and
bar
we're
committee,
all
and one of my
right.
distractions is I can't remember all this because
Okay.
we've had multiple mediation bills that have come through in relation to the non-lawyer mediations.
Mr. Gilbert or Ms. Sewell, you either one of you want to tackle that?
I can tackle the bar part.
Mhm.
This issue is the one, we hadn't had multiple different types of bills. This was the bill that first was brought to the ACL. The ACL, for those that might
What
not
year,
know,
please?
huh?
What year did we do that? Because is this a 19 bill or a 20 bill? Was this the 19 session from the Senate or the 2020 bill?
2020.
This is 2020.
We,
If
as background,
If it's
we,
2020.
Let me
then I'll hush. I'll
let me
hush.
can I interrupt you real quick, and I'll let you continue. You're supposed to present a bill in another House committee now in Banks and
Sir?
Banking. You're supposed to present a bill in Banks and Banking right now.
I am, Mr.
Do you
Chairman.
want to go on over there and
With-
do that? I
With
think
your
y'all
permission, I would like
y'all had a
to.
hearing yesterday,
We-
so
we-
today it's really just a vote, I think.
Should be, but there's been a proposed amendment to it that I do need to be present for and probably address.
Do
May
you
I?
need to have someone to mediate the dispute?
I do, Mr. Chairman, but there are no rules that would apply.
Okay,
And so that's our problem.
We're working on that. So,
I know.
but if you need to be excused, someone brought that to my attention.
Thank
You're
you.
welcome to be
I-
excused.
Whoever did that, I appreciate.
Yeah.
I started to, but I didn't want
It's
to
a bright
be
lawyer sitting
disrespectful.
up here, right here.
I didn't want
Yeah.
to be disrespectful to.
No, not at
your-
all.
your
We
committee.
completely understand. We're in
Thank
an interesting time now, more so than usual, with trying to get things done. So,
Mr. Chairman, I'd like
Yeah.
to make a motion to table. That might be a courtesy to Senator Kennedy, where he could come back, where we can kind of bring together this history.
the chair's not ready for motions yet. I'm interested in the answer to your questions, and we've got the people here that can answer, and I'm gonna listen to them now. Yeah, go ahead.
in 2018, this bill was presented to the ACL and we had this concept was presented to the ACL from the committee. The committee voted on it and approved it. But there was some questions brought up and all like that about how far we had a lot of other legislation that
I
year.
promise you, this is the last time I'm going to interrupt you.
Okay.
Was that the uniform bill that was presented in 2018?
Yes,
Okay.
it's the same bill.
And then there was a path that went differently. I
All right.
promise
Well,
that's the last time.
And by the way, it's Rusty, so you can interrupt him again if you want to.
Don't worry, she will. So in 2018, it was brought up. We didn't go forward with it, mainly because we had a lot of other legislation, had some other issues involved we were looking at. In 2019, we came back to, or the committee came back to the ACL. The ACL approved it again in 2019, the uniform, and we started in, but there was some questions about authors and who was going to do and some other things. And so the summer after 2019, and I'll beg on the chairman, we went to the chairman, I'll tell you, 2019, the chairman asked his aide at that time, who's Jordan Reed, back there, to start working on it. We started working on it, but it was right before the session. So in the summer of 2019, we got together and the chairman was nice enough to get together with Evan, who came in as his, and said, y'all work it out, work on something. We worked on something, and at that time, we decided, we'll go forward. We worked on it. We were imposing on Representative Rich to introduce it. We were going to have a bill. So we came forward to 2020 with getting ready for the bill. Unfortunately, she had her illness at that time. And then we went to John Kennedy, who also was a Board of Governors member of the bar, and he introduced it this year.
But
and
the
it passed
draft
the
of
Senate.
what was introduced by Senator Kennedy in 2020 was not complete when the ACL reviewed it in December 2019. Am I right or wrong about that?
That's probably true because we don't have the final drafts
Right.
usually when we look at them in the ACL. we're better at that, now, but you still, I mean, it's just like with the fiduciary bills and all, they change is going on.
And so
So
this
that's
bill
the
was-
history. We've never passed a mediation bill. We've passed an arbitration bill that goes back to probably 10 or 12 years ago, Shelby, somewhere like that.
Yeah, 2013.
Or 2013. We passed an arbitration bill, but we've never passed a mediation bill. But you've heard about it enough in the ACL that
but not have it. We've not had a draft of the ACL, and the Georgia dispute resolution under the Supreme Court that manages all this. Are they here to testify, to answer my specific question? I'm just curious about who can come into the mediation. I'm just using that as an example because that's usually a very tense matter.
Mhm.
It's not a tense matter in the business community, but it is when you're in family disputes.
Yeah, and I see your point. I mean,
How is that addressed in all the other rules and
I
statutes that are out there? Do you know? So what does May mean?
Yeah,
Who
and
decides May?
know a court reporter one time that was setting up in the room to take a deposition in a divorce case, a very very heated one, and the attorney brought one of the spouses into the room that was aggrieved in the divorce process. That spouse thought that the other party that had broke the marriage up was going to be there today, mistaking the court report for that person, and the court reporter almost couldn't take down the deposition because their hand was squeezed so hard when the hands shook with each other, and the lawyer had to say, no, that's not so and so. So I understand the tension that can be in the rooms when you have a family proceeding, and that's what you're talking about, right?
Which is most of what goes on.
Can you respond to that particular rule that you pointed to in that question?
I can't respond on behalf of the family law section
Sure.
that saw a copy.
I didn't know
of this bill.
if that discussion had come up during the process or not.
I don't recall a particular discussion about 917.9, Representative Oliver.
Okay. Ms. Silcox.
I appreciate you coming today very much. I would say that I think part of the beauty of mediation is a relaxing of the regular rules. And I think to over lawyer the mediation process, especially for people of lesser means that can't afford King and Spalding, is perhaps a little bit of an overreach. I do think that if you're in an international dispute, that the parties can always specify the rules they want to operate by. You could certainly use this as a reference for those disputes. But I do think that at the end of the day, some people go to mediation. And in fact, one of my best friends in law school was my classmate, John Miles, and he's, of course, the CEO of the largest mediation firm in Georgia. And he very much would testify to Mary Margaret's comments that, that this is an alternative for the everyday person. And I think that to over lawyer that process takes away from the beauty of mediation.
If I could respond to that, I think that the idea of this is that so you don't have to over lawyer the mediation with the mediation agreement. You got a simple set of rules, and you don't have to have someone throw in a Miles ADR mediation agreement, which I know Miles Mediation has, and throw it to a party that hasn't had to study that at the last minute and think through it. This helps deal with that situation and simplifies it. So that's
I'd like for you to flesh out that point. So your argument is that this actually makes it simpler.
Yes, sir.
Rather than harder.
That's right.
And I would argue Ms. Oliver's example that it makes it more complicated. That's just my viewpoint.
Okay. Well, I know I've talked with folks at Miles ADR in particular that are very much supportive of this bill, and some of them are in the dispute resolution section. But I'd like to go back to a point Representative Oliver raised
Please.
about the Arbitration Act and some of the history, because arbitration obviously is a different type of dispute resolution mechanism from mediation. But that was the first thing that we tried to accomplish with the committee and passed that statute back in 2013. And to answer your question, has it helped the state of Georgia in a measurable way? I think that, yes, it has. At the center, I can't speak to how much funding has been given to the center over at Georgia State, but
I'm interested in that question.
And I don't know the answer to that, but I do know that I think last year what I heard is that they had over 150 hearing days at the center, and they're charging people for use of the space. And those folks, sometimes they're from Georgia, sometimes they're coming from out of state, and that's has created some revenue. I don't know how much, but I think also you look at surveys now where people say you would want to go in the United States to conduct an international arbitration. And 10 years ago, nobody surveyed around the world would have said Atlanta, Georgia. And the last survey I saw had us, we're usually ranked now number 3 or number 4. New York's first, Miami's usually second. They started a little bit before we did. They're about 10 years ahead of us with some of these legislative efforts. And then it's usually Atlanta and Washington, D.C., then in a tie, or third or fourth, going back and forth, which I think shows that these types of legislative efforts, and then also the support that we got from the courts and the 11th Circuit Court of Appeals has been a great friend of arbitration, that is international community. Atlanta's a great place to do this, and we're doing more of them here than we used to.
Are any mediation?
Hold on one second, Mary Margaret. Try now.
Are any mediations conducted at the arbitration center? Or is there any overlap? I assume there is.
Yeah, I've not mediated a case there, but I know you can. So the space can be used for arbitration or mediation. It's more set up for arbitration because it's got a hearing room, it's got interpreter booths and other types of facilities. Position or other purposes as well.
So have you seen any change in arbitrations? I'm sorry. Have you seen a change in arbitrations, the number of arbitrations being disputed locally since COVID? I guess I'm just curious. That's the $100,000 question, I think, is how much is it going to be done by Zoom going forward versus coming to a location?
It's funny you mentioned that. I spent yesterday, was my first virtual deposition, and I had to depose a guy who was sitting in London, and I was struggling with introducing, I think I had 35 exhibits I used yesterday, and you can't hand it across the table. You've got to press buttons and make sure he could see it on a screen, and it was a little cumbersome. I think that I've done an arbitration hearing. I did my first one internationally, actually 2 months ago. Did it virtually. I'm doing mediations virtually now. I think that we're doing that because we have to right now, because we can't get on airplanes, and parties are going to find a way to move their disputes. And if the courts are closed, the judges now in the business cases are saying we've got enough problems on our hand with a criminal docket. You've either got to keep your case moving or else it's just going to die on the vine. So that's what we're trying to do, find a way to make it work. Now, at some point, this pandemic's going to be over, and people are going to be thinking, well, okay, well, let's get back in a room together. And I think mediations, everybody who's done it knows that you miss the dinner the night before, you miss the hall room conversation where you can peel away one of the parties, or particularly with these multi-party mediations where there might be 30 or 40 people there. It's those side conversations that you can't really do in mediation. I know Zoom's got a virtual room or a parking lot where you can have a side conversation, but it's not the same when you've got somebody, you're trying to have a private conversation and the dog runs in behind them and the kids are knocking on your door. And we're all struggling through those here today. And everybody's had that situation probably in this room, but I think everybody's going to want to get back together. I don't think that there's going to be an end to mediation because of this. I think it's just going to grow. And I think that there's an opportunity now that we've got when people start getting back on airplanes to get some positive momentum behind this, and to be able to signal to folks outside of Georgia that we're open for business and we got a great platform for you to use if you want to resolve your dispute here.
I asked Tracy to come in because she's outside. Tracy Johnson, I'm gonna let her introduce herself because we talked about the dispute. I'll let her introduce herself. I mix up because she can give you a little reason of why the commission is for it, and they're the basis of it. So Tracy, if I'll just let you. Yeah.
Yes, sir. Thank you. Thank you. Thank you for having me. I'm Tracy Johnson. I'm the Executive Director for the Georgia Office of Dispute Resolution. We are the administrative arm of the Supreme Court Commission on Dispute Resolution. This, like Shelby said, this initiative came before the commission, and our commission felt like this was in the best interest of mediation in general for the state. We have our court rules. And I think one thing we're talking a lot about pro se litigants. We're talking a lot about maybe mediators who aren't attorneys. About 40% of our registered neutrals are non-attorneys. We have a lot of unrepresented litigants in mediations, but what this does is if they're unrepresented, they don't know what contracts to draw up to protect them. They don't have that knowledge, that information. So if they're going outside of the court system, they don't really have any protections. And what this would do is offer them the additional protections that are offered under the Supreme Court rules. We studied all of these sections in great depth as they would conflict with the Supreme Court rules, and did not find any conflict. They would only strengthen what's already in existence for Georgia. So I don't know if that answered your question, Representative Oliver, but we do feel like this is a plus, especially for those unrepresented litigants.
Questions from members of the committee?
Who is Shelby? Forgive me. I keep hearing Shelby talking about.
Mr. Gilbert.
Yes, ma'am.
Mr.
Yeah,
Gilbert.
that
Now that
the
helps me a
chair
lot.
once again added to the confusion by calling him Shelby. So Mr. Gilbert. Yeah. It's our goal to have Ms. Oliver confused as much as possible during these meetings, and yeah. So okay. Any other questions? Do we have any?
Well, may I follow up?
Please,
Sure.
you certainly may.
What is the rule on who decides who's in the room for a mediation? Under what document and what rule specifically?
And when it comes to appearance at mediation, there's not a Supreme Court rule that talks about who's supposed to be in the room.
Okay, let me interrupt you.
Yes.
If that's, I think you're right.
Mhm.
I think you're right. Then this changes the law how?
Do you have a copy of the bill, ma'am?
170.
I want line 179, I believe. Isn't that the line, Ms. Oliver?
Yes,
179
sir. 179.
is
and
what
180.
she's referring to. And she particularly was asking questions earlier about domestic mediations.
Well, now it does say in the rules, in the uniform rules, that attorneys are never excluded from mediation.
I'm
That
not
they
worried about
can.
attorneys. I'm worried about the family members.
But it does say in the uniform rules that parties have to appear at mediation. Now, it does say that. It doesn't go any further than to say whom else may be involved.
That's right, it doesn't.
Yeah.
And this does. And that, I'm just using it as an example.
Um,
I think this is pretty bad.
Well, I think that the individual has to
Yeah.
be designated by the party to the mediation as someone who they say may attend the mediation.
That
That's-
happens all the time in domestic cases, and it's frequently, I just want to figure out what this rule means in terms of the operation in the average for the 40% of the people out there that are bringing their mad husband or boyfriend or whatever.
Maybe that's a question you can find out for Ms. Oliver as well.
Yeah,
Okay.
and my read of it, just looking at it, is that a party may invite that individual. It's up to them. If they don't want to, they don't have to.
Okay, but what you just said is that if I want to bring my first husband, who is the bad actor in the view of some, then that's my right to do it, and nobody else can object.
I think the
mediator
point
can't object.
being that two parties in a domestic dispute who are even ordered to mediate now, because I think, although I don't do domestic work, I'm welcome to be corrected in the room. There is court ordered mediation, is there not, for domestic divorce
different
cases?
for a lot of,
different in
a lot of
every
counties.
county.
Yeah.
For divorce cases. And so if we adopted this, that would be the rule in a mandated mediation. Whereas now, I assume if there is not a rule, then the judge, you could appeal to the judge to have somebody excluded, or there could be an agreement between the parties to do that maybe. Is that where you're heading, Ms. Oliver?
Under the current operations, which I don't believe there's a rule, but somebody's going to correct me, the mediator decides who's in the room and not the party. That's kind of the unwritten you're claiming it's not written, but Mr. Chairman, we've lost a quorum to whatever extent we're concerned about.
We have
quorum.
not.
Okay.
5 is a quorum. And we have people in Zoom up here.
Okay.
And we have a quorum in the room, actually.
I can't count today either.
So if I may, the mediation rules are a lot more flexible. If all parties agree, anybody can be in the room. So if parties agree that they can bring in new spouse, which sometimes can be helpful, sometimes harmful, we are actually updating the rules for mediating cases involving domestic violence to indicate that a DV advocate can be a part of that process. So there is some structure around. I agree. It for the most part it's understood, but usually local rules, the local court programs can promulgate their own local rules, and a lot of times they deal with appearance in those local rules. The Supreme Court provides that framework for them to do that.
Other questions? Mr. Reed, would you like to stay back there or would you like to come up front?
Whatever is more pleasing to the chair of the committee.
It's up to you. Your choice.
I'll go through.
Okay.
Nice to meet you, Shelby.
Miss Oliver.
I'm sorry I have to go.
Ms.
Mr.
Oliver,
Chairman.
no, the chair intends to hold this bill. There's been several questions answered today, asked rather, that need to be answered. There's information that Mr. Gilbert's going to get to us. So it may very well be on the calendar again tomorrow, but the chair is going to hold this bill.
Thank you.
Okay. Well, you can't sit behind the pole. Either come right up front or oh, I see. Mr. Wilson stole the chair, so he wouldn't be behind the pole. Just come on up front right here in the middle. Sure. Mm-hmm.
My hot seat. Thank you. Thank you, Mr. Chairman, for giving me an opportunity to speak. I'll make it
Please
brief.
introduce yourself.
My name is Jordan Reed. I'm with Georgia Trial Lawyers Association, and I'm here to talk about SB 484. And a couple of things that got brought up that I want to address was when I was looking at how many states have this, it looked to me that the ABA says that 12 jurisdictions have adopted the Uniform Mediation Act, but most states, when they adopt it, have made it unique to their state. And so it isn't just plopping a uniform code in here. And the state with the most expansive version is California. And so looking through the bill, there's just some structural issues that I would like to call to the committee's attention. So privilege and admissibility are different, but importantly, there is no reference in this piece of legislation regarding the protections provided in 24/408B. And the fact that, to me, that is, it may be an unintended consequence, but if it's an intended consequence, it rescinds an important part of our evidence code's prohibition under that subsection, because it prohibits conduct or statements made in the course of negotiations or mediations from being admissible. It seems to me to be a workaround of our finely crafted evidence code and civil practice act. In fact, the idea of privilege is located in 6 different newly created code sections. And so when there was discussion saying that this streamlines the process, I unfortunately have to disagree, because I believe you would have to be digging through multiple different code sections, and it could actually be found to be an impermissible violation of the due process clause, like our garnishment code was in 2016, because those provisions likely do not provide adequate notice to those involved, particularly as to their statements made in anticipation of negotiation as being privileged or otherwise inadmissible, or what is privilege given the multiple different and ever-shifting nature of the privilege. Beyond that issue, I also like to call to your attention, beyond that issue with the purpose, structurally, the definitions create loops that frankly are incongruent. For instance, definitionally, the chapter applies to mediation, which is defined as being conducted by a mediator, but then the definition goes on to define mediation communication as one that occurs for purposes of conducting, participating, etc., mediation. So all acts to this by its terms are not just limited to an actual formal mediation process with a mediator, but could encompass negotiations themselves. In light of those concerns, I actually reached out when I first came into contact with this in 2018, to Professor Paul Millich. That's the Georgia State law professor who worked with then Chairman Willard of the Judiciary Committee and rewriting our evidence code in 2014. And so I wanted to see if this was his take as well. He said, yes, he agreed it would impact the protections we currently have in our evidence code, which is another important reason why, at a bare minimum, there needs to be some sort of citation or reference to the fact that in no way is it permissible. An opt-in strategy seems like a potential viable solution because it goes down to voluntarism. If people can voluntarily choose to abide by these rules, that's totally different. But using the coercive nature of state law to say you have to do things a certain way, I think is Representative Silcox, Chairman Silcox brought up, is going against the whole point of having voluntary mediation. So I just want to bring those issues to your attention, and I'm happy to discuss further. If there's any questions, I'm happy to take those as well.
Questions of Mr. Reed? Mr. Gilbert, do you want to respond to any of that?
Couple reactions to that. First, I'd agree with Mr. Reed that there are 12 states that adopted it. California is not a uniform mediation state. They haven't adopted it. They've done something completely different and gone in a different direction. They're actually looking, from what I've heard, folks in the bar there at trying to come back closer to a uniform statute, given their experience with litigation arising under what they actually passed. As far as Section 408 of the Evidence Code, I think that it's a great thing that we've got. And I think that most states actually have some version of 408 in their evidence codes. It took Georgia a while to adopt that, and we did. I think that's a great thing. I don't see anything in this statute that would override the existing protections that we have for mediation communications. If anything, this reinforces and goes beyond by adding the privilege. So I just don't see the conflict, and we've taken those concerns back to the committee. We've discussed them with the Dispute Resolution Commission, and I appreciate Mr. Reed bringing those to our attention last summer when we were talking about these issues, and we just didn't see it. And we see a lot of merit, though, in sticking more closer to the Uniform Mediation Act, because again, what we're trying to get at is a uniform act that's similar to what other states, and Mr. Reed is right, that most states that have adopted it have done a few things to comply or to comport with specific sections of their state codes, which is appropriate. And I think that we've tried to do that with our committee that came up with this bill. And I think that we've accomplished that and addressed those concerns.
Anybody else on Zoom? Okay. I do not believe we have anybody else signed up for the bill. So the chair's intentions are to put this on the calendar for tomorrow. As I mentioned, there have been several issues that have been raised. There's information that you've been asked to bring. I know you said you were going to electronically send something to us. I know Ms. Oliver asked several questions about some of the background and things that have happened. So it's the chair's intention now to put this on tomorrow. And we also need to get a resolution to the enactment date, or rather when the provisions of the chapter were to go into effect, if it were going to, if we did pass the bill and the governor signed it, and that's that January 1st date, and you may be settled on that, but let us know what you think on that as well. Okay. Thank you all today, and we'll stand adjourned.
Thank you, Mr. Chairman.